Thanks, Charles. Let me start off with screen sharing here, and let me go to screen two and share. All right. Can you guys see the screen?
Yes.
Yeah. Okay. Fantastic. So let me start from the beginning. Okay. So good afternoon, everyone. Today's seminar is on how experienced physicians negotiate employment agreements. The reason why we put this seminar together is really because there's a big squeeze going on between private equity groups, corporations, just squeezing in on the healthcare industry, and the way it impacts physicians is really pretty harsh, given the fact that physicians have such a big public service component to their profession. And so I wanted to bring this to everyone's attention, only because I want physicians to figure out what they need to do, how they need to look at things, and what the corporations are doing in the background. And whether you happen to be on the employer side or the employee side, you will pick up pointers today that I hope you can use in your employment negotiations. And what I'm hoping to do is just to make you more educated about what to spot and how to go about spotting it. So by way of background, my name is Ben Mirza. I am a former CPA. I have a Juris Doctorate from Nova. I have a LLM of taxation with a concentration in mergers and acquisitions from Villanova University. And as of recent, not that recent, but as of recent, I do have a Master's of Public Health from Yale. And the reason why I am in the healthcare sector is because I am very passionate about where the healthcare industry is going, and specifically as to physicians. I'm married to a physician. I come from a family of quite a few physicians that are in it. So, this topic is near and dear to my heart. Although I was never meant to be a physician, I love being a lawyer. However, I love being a lawyer for the right good, not, I don't practice medical malpractice or any of that. Majority of my work is really related to mergers and acquisitions as they take place. Physician employment contract reviews, I do quite a few of those. And the other thing I also do as I've gotten involved is more and more investigation stuff, like from the Department of Justice as it relates to the Stark laws and the anti-kickback rules. So, all right. So who should be listening to the seminar? It's really physicians and highly qualified professionals, including those that are business executives in the healthcare industry. The reason for it is because there's a PE push going on, PE meaning private equity, and there are golden handcuffs that are in play. Oh, before I go down these short stories, just remember, this presentation is for informational purposes. It's not intended to be legal advice. However, I am trying to give you a roadmap of what you need to be looking for. So we're going to be talking about certain situations, and hopefully you'll get some tidbits out of it. If you have any questions, ask on the spot if you can, because I'm sure if you have a question, others do too. You're welcome to put it in the chat, or you can raise your hand and we'll get to you. Or you can just speak up as well. You're welcome to interrupt me if I don't happen to stop. So what I can tell you is I've seen physician employment agreements that have a radius of 1 mile, and I've seen a radius of all across the country. It's the radiuses of how much and how far a physician non-compete goes really has no boundaries. And the reason for it is because Florida is so in favor of the corporations and how to interpret non-competes that the broader a employer writes it, the more leeway they will have in court to be able to navigate through the situation and try to have the court rule in their favor. That's why it's pretty broad. It's We've got to, we just have to get our arms around this as professionals in the healthcare industry. And I'm glad you are all on here today. So what's at stake? Who is being protected through contracts, right? So number one, businesses for sure are gaining a level of protection. Why do they need protection? Because there's an expensive infrastructure that's in place. It's expensive to actually pick up patients and employees, good employees, or the whole recruiting process, whether you look at patients or employees, is really, it's expensive. Conversely speaking, the physicians are being commoditized. They're getting restrictions upon their professional freedoms. They are reaching point of burnout. There is what I call, or what I've heard other people call, it's basically check the box medicine. And what's happening is that patients end up with a mixed result. I think that their economic pressures are hopefully lowered by doing this, but at the same time, I'm not so sure that their care is as great as one would hope for. So with that said, here is today's agenda. This is a 50-minute presentation. We're already about 5 minutes into it. And we're going to talk about basically 5 things. Number one, strategizing your future employment, compensation models, the different types of compensation models that are being used in the industry that I'm seeing. There's probably some others, or there's variations of these. Then we're going to talk about non-competes and restrictive covenants. We're going to talk about professional liability coverage and how to look at and review professional liability insurance that your employers may have. And then last but not least, what an employer's obligations are. And I also want you to take a look at this. There's a 15-point checklist that's on our website, and it's on the MirzaHealthLaw.com website. If you just type in 15-point checklist for physicians, Mirza, it'll pop up. Plus, at the end of this seminar, we will be sending you a copy of this presentation, so you'll have it as well for your records, because we're going to fly through a lot of stuff today, and I'm not so sure, in the interest of time and wanting to bring everything to you, I'm going to end up rushing through some of this stuff, and I hate for you to miss it. So we'll get that over to you. So let's start off with strategy for future employment. What experienced physicians know is that where they are today is just a stepping stone to tomorrow, right? So what are they looking at? What are the stepping stones? The stepping stones and their variations are many. And here I've listed literally 4 different categories, but there's many different variations in between. First and foremost, I mean, let's start off with like the individual practice or small practice groups. Those are really the small groups that have a lot of autonomy. Their compensation really varies. Some are highly compensated, some are very lowly compensated. So it really varies on their specialty, what they're doing, and how they're taking advantage of being in the business of medicine. Being in the business of medicine can be highly lucrative, but it's got to get run right. And that means you got to get the right mindset, to the right advisors, to building the right presence, and that's how you start that. The other thing that you will see on here is that there's also large corporations, large practice groups, and insurance plans. These guys are all recruiting physicians. What ends up happening there is there's a lot less autonomy, but there's a lot more regularity in the daily schedule of a physician. So some people actually prefer that. Sorry if you see, like, I've got a window on that side, so I'm not in my regular environment today. I'm in a hotel, speaking from a hotel outside area. So anyway, the third part of this is hospitals. But we also know, if you have actually looked at hospitals and their corporate structures, there's many different kinds of hospitals. There are the not-for-profits, the teaching hospitals, the research hospitals, and the private hospitals. So the most common type of physician that'll be in there is really obviously the ED, the emergency department physician, the anesthesiology groups, the pathologies groups, radiology, and surgeons. So, I've spent a lot of time in the health in the hospital sector as well as insurance plans on the inside. Last but not least, the private equity groups. This is where I think a lot of the physicians hope to end up one day for hopefully a big payday in return, right? So maybe a private equity group or a health plan or a managed care organization or even a ACO takes them on and gives them some sort of a big position inside their company to with some really sizable stock options and bonus payment structures. And that's really what a lot of physicians are also hoping for, because they see the money that's in the business of medicine. So if you are an individual that's going to enter into an employment contract, what do you see on your 5-year horizon? What do you see on your 10-year horizon? You've got to really figure that out. Are you going to hopscotch through this maze of these different types of employers? Are you going to stick to one industry? And that will make a big difference in how you negotiate your employment agreements. If you are currently looking to go work for a large corporation and then eventually go set out on your own, or go from a large corporation to a private equity group, you're going to need to be mindful of that when you enter into these employment contracts. Hugely important. So with that, what I want to do is I'm really only going to touch on 4 other major points, but I want you to see the gravity of it, so you can negotiate the best contract you can for yourself. And if I can be of any help, you're welcome to call me. But I'm trying to get as much information out there as possible. So let's look at physician compensation model. Right, this is our second part of that agenda. So what are the different physician compensation models? Number one, there's a fixed compensation model, which is generally the salary. You could be paid monthly, you could be paid annually, you could be paid based on a daily rate, even sometimes hourly or half-day rates. As a physician gets employed, they could be a W-2 employee, or they could be a 1099 contractor, or they could be a straight up having their own private practice, be the quasi-employee of a particular group. So it can take multiple forms, but we'll go through the actual what to consider as you are getting put into this fixed compensation model next. So let me go to number 2 before we go on to that slide. There's also what's called a productivity compensation. The productivity compensation is typically based on 1 or 2 things. One is either net collections, or they give you certain dollars per WRVU, which means basically the RVU equivalents, right? So when you look at how many WRVUs can a physician earn during a year, it really ranges, and it's significantly different. Some are as low as about 4,000 if you're a full-timer, to as high as about 10,000. So the WRVUs can vary on the type of specialty that the physician is in. And that's the productivity model. But then we'll talk about the special considerations under this variable based sort of a compensation package. Hold on tight. Next thing that you want to look at is the bonuses paid. How are the bonuses paid by these organizations? Is it for reaching a certain level of WRVUs? Like if you reach 4,000 RVUs, what are you getting paid? Is it one rate? And if you reach 6,000 RVUs, is it a different rate? Same thing with collections. If a physician generates $1 million in revenues versus $2 million in revenues, as those thresholds are met, what percentage of collections is the physician getting? So you got to be mindful of how they are doing the math in the background, because I can guarantee it, there's accountants and lawyers in the background, and also keep in mind there's what's called in-practice referrals. In-practice referrals also give some level of credits to the physicians for doing in-practice referrals. So like, for example, if you have a cardiologist within your, let's say, general internal medicine practice, if you guys are a part of the same group and you go and the patient goes from one physician to the other, they will take a look at that. And that's what's called an in-practice referral. Out-of-practice referrals are very different. So they will look at that, and they will see what sort of a value you're bringing as a physician to the group. The last but not least, number 4, this is not really an employment model, but it's often rears its head as like an employment model. Okay. And what I mean by that is each physician is looked at as if they are a business unit, like if they are a practice based compensation package. So what the physician will get is a percentage of gross profit or a percentage of net profit. Those are, in accounting terms, those are two very, very different words. As Charles will tell you, Charles is a CPA. I am also formerly a CPA. I can tell you that us accountant types can slice and dice with the best of them. And we can define gross profits and net profits in multiple different ways. There's one general way of looking at it, and then there's multiple variables that go into it. So, you have to really pay attention to what they're promising you. It's not really a typical employment model. This is really a business unit or a practice-based compensation model. And then in this this fourth type of model, the model number 4, there's also what's called a corporate overhead allocation that's applied to the compensation package, where the corporation takes X percentage as a part of what they do for the business. So like, for example, when there's HR, when there's billing, when there's recruiting, when there is IT, computers, software, the overhead side of the corporation gets compensated because they are reimbursed for their expenses that they're incurring. So you have to take a look at this with a fine-tooth comb. Number 4 is not to be taken lightly. Really, the best scenario for that is for you to engage a accountant/attorney to help you get through that. If you don't have an accountant/attorney like me, perhaps what you may want to do is get your CPA involved and get your favorite lawyer involved. It doesn't, like, you just gotta make sure that you're dotting your I's and crossing your T's so you can maximize the compensation. So here on this next slide is really the important considerations that I think you should look at when you are reviewing your compensation model. If you're looking at the fixed compensation model, what's your paid time off, PTO, right? Are you getting paid for the federal holidays or not? If you're not getting paid for the federal holidays, well, and it's just going to go towards your PTO credit, well, how many PTOs are you getting? Then also there's vacation. So typically there's 10 federal holidays, right? And then vacation time can really vary anywhere from 2 weeks or sometimes even 0 number of days to up to like 4 weeks. I've even seen 6 weeks, but between 2 and 4 weeks is pretty normal. What about sick time? Sick time, paid time off. So some employers, what they'll do is they'll put it all together and say, hey, you get 20 paid time off days and use them however you want. And then does that include continuing medical education days? Meaning, like, if you go to a conference, if you go to some sort of educational sessions, is that going to be a part of that or not? So even under fixed compensation contracts, you got to take a look at your packages very specifically and carefully. The other part of the fixed compensation is, are you getting health insurance? Are you getting retirement benefits or disability insurance? Will there be Family Medical Leave Act time off? So in case if a loved one, a relative, or a pregnancy, or a birth, or a death, during times like that, are you going to get any time off for your family member? And that really relates to the larger employers, but that's another consideration you got to give. So that's just the fixed compensation. So when you go through your employment contract, you want to make sure that these items are really well ironed out as it relates to compensation. Then let's get to the productivity compensation. In there, if you're going to get paid under the productivity compensation model based on collections or based on WRVUs, you got to figure out, hey, who's going to be responsible for coding, billing, and tracking. Those are 3 very different functions. You may start off with a coding yourself, but that coding may be getting changed in the background. It's either getting upped or it's getting lowered or it's getting left the same. So you got to monitor that. The next thing is billing. When the bill goes out, Are they doing it timely? Are they recovering as much as they can? Is the corporation recovering as much as they can from the payors? Because if you're late in submitting a bill, you're going to lose out on services that you provided. So you've got to really make sure that these issues of responsibility are well laid out. And tracking is everything, folks. If you're a physician, you want to make sure that your employer has the ability to track what your billing is. If they're not able to actually track it, I challenge them that they can't, number one. Number two, I think you got to be careful. Then that tells me that they're not running their shop in the right way if they are not able to track and tell you specifically what you've billed on what month, under what codes, and so forth. If they're not able to tell you that, that's highly, highly problematic. So be careful of that, because that's a basic billing 101. If you look at a HCFA form 1500, which is HCFA, I think it's like a Medicare form, HCFA 1500. If you HCFA 1500, if you Google it, you'll see all of the variables that are required by Medicare, what needs to get reported. And the insurance companies require roughly the same fields to be provided to them in order to get payment. So the employer needs to be able to give you the specifics of how the billing is taking place. Then you have to look at collections. What is defined as collections, right? So number one, is it collections within a certain time period? Is it collections, what happens to a missed bill? So let's say an employer misses billing out on something and it's their fault. Is that going to be something you're going to get paid on or not, even because you did the service? And conversely, what if the employer is paid for something that you did, but later on the insurance company comes in and does an audit and there's a clawback? What happens to that if there's a clawback of money that goes back to the insurance? It's almost like a refund, right? So is the physician going to be getting penalized for that? Should they get penalized for that? I'm not so sure, and I'm not one way or the other, but all I'm saying is you got to have language in there that talks about that. Then what you also have to look at is post-employment effects of your contract under that model. So what I mean by that is, for example, if you have a contract that ends in January and you're on a percentage collection basis, right? What happens to all of that trailing money that will come in the next 3 to 6 months? And what happens to all of the other money that relates to, like, let's say ACO sort of bonuses at the end of the year? You've got to take a look at the post-employment effects of what happens to your money that's coming in that you've helped generate. Are you going to get the annual bonus that shows up, let's say 8 months or a year and a half after you're gone at your employer's doorstep? Are you going to get the benefit of that? And that's something that you need to actually negotiate and clarify. And let's move on to our next model. This is where the bonuses are paid based on reaching a particular WRVU equivalent, collection thresholds, and in-practice referrals. Is anybody tracking that? You got to get the actual reports that'll help you get there. Number 4, the partnership track, right? Back to the business unit model. What I want you to understand is that direct expenses, corporate overhead, and gross profit and net profit means different things to different people, to different corporations. Us among CPAs have a certain level of a level of understanding amongst ourselves as to what we think is appropriate, but sometimes these employment agreements define them differently, very differently than a CPA would. So you've got to negotiate the terms that's in there. So, like, for example, if you have a direct expense, that's a part of a practice. If you have a cell phone, is that going to be considered a direct expense? And are they going to take it out of your paycheck, or are they going to help pay for that? Or is that going to go into corporate overhead? I don't know. That's something to actually be negotiated. And I've negotiated in multiple directions, even if it's something as simple as a cell phone, a car allowance, a travel allowance. Where is that going to fall under? A CME allowance, payment for education. Is that a part of direct expense, or is that a part of a corporate overhead? What's going to happen to the expenses for the IT network or the IT, the technology that's provided to the physician. Many different definitions are in play. This is a highly complex contract. Don't negotiate it on your own. Just reach out to somebody, definitely at least somebody who understands finances and understands those definitions. And I think, you'd be best served to engage your CPA or an attorney like me. But anyway, if I can help you with that, you're welcome to call me. So let's now moving on to non-competes. This is why I'm only touching on literally 4 topics today, even though there's a lot more to go about. So let's talk about non-competes. Non-competes, compete agreements is generally how people refer to what's called restrictive covenants. There's multiple types of restrictive covenants inside employment contracts. There's one that's obviously a non-compete that basically says that physician will not go and work for another competitor that's directly in the same line of business as employer number 1. Okay, that's a non-compete. But then there's also what's called a non-solicitation. What non-solicitation could apply to is that the physician is not going to go and recruit the patients. Okay, what else can they not recruit? Oh, maybe the employees of the business. That's another one. What else can they not recruit? Perhaps going to the same health plans. Now, how is that even possible? Yes, I have seen contracts that say that physicians cannot go to a health plan and become a part of it, because if you are under Blue Cross Blue Shield under employer A, when you move over to employer B, you cannot go and join Blue Cross Blue Shield under employer B. Now, that makes no sense whatsoever, but it's in the contracts at times, and I find it pretty bad and pretty overreaching when they do that, but it's in there. The last but not least, the confidentiality provisions. The confidentiality, what'll happen is employers will say, we employ all kinds of interesting techniques and knowledge, and we've gathered all this knowledge, and we have our own tools of the trade that we've uniquely developed. So we don't want you taking any of that. Mr. Physician, you can't take any of our confidential information. But really, there's a problem with that. Each employer is kind of unique in certain ways, but a lot of employers use the same sort of techniques in and out, depending on who their consultants are. And they think that they have the best things in sliced bread, but there could be 50 other competitors in the same geography that are using the same tools and techniques that they are. So what's confidential information? So you got to negotiate these sorts of things, right? So what I look for is reasonable restrictions based on the employee, imposed on the employee. Reasonable restrictions imposed on the employee. Is the geography reasonable? So put it this way: if they say you cannot go and work anywhere in the state of Florida, even though you may happen to be working in Broward County, that's problematic to me. What happens if you happen to go to Georgia? Are you still considered, as competing against the employer? What if you move one county over? Are you still considered, to be competing? It depends on what the mileage, the radius, and the specialty is. Also, the industry, they have to be specific as to what industry they consider themselves to be in, meaning the employer. The employer has to be specific as to what industry they think that they're in. A lot of times they'll just leave it as general healthcare. Well, guess what? That gives them so much leeway and bandwidth to classify themselves as however they wish. And so the unique thing about Florida, again, is it places the burden of proof largely on the employee. As soon as an employer comes forward in the court, now the employee has to say, oh, I am not in the space of healthcare. I'm only in this particular niche. Well, is working for a health plan in the healthcare industry? Yeah, some would argue it is. Others would say, no, it's in the financial industry. You can see arguments as to both pieces. Hold on, let me just see if there's a question here. At this time, okay, sorry. So, The applicable time. How long will these restrictive covenants apply to the particular physician? Is it going to be a matter of 6 months, 12 months, 2 years, or 5 years? Generally, Florida courts have ruled that anything longer than 2 years is starts to get long, and anything more than 3 years, they start to look at it with much more scrutiny. But there is no litmus test as to what is the right amount of time that a physician could be restricted from competing in the same market space. So you got to look at these things. What persons or parties can they not solicit? So, as vendors, how about referral sources, right? If the referral sources are all belong to the employer and they're the ones who came up with them, so I get it. That's fine. Keep it protected. However, a lot of times physicians are getting referred patients from other physicians that they know, they may have graduated with, they may have worked with on a particular association or a particular not-for-profit. And that's how they're getting referrals, is through people that they just know in the community. So it's really important to iron these things out in the employment agreement. Now, let's take a look at confidentiality. What does confidentiality apply to? When you look at confidentiality, does it apply to the names on in the patient database? Does it apply to like business records? Does it apply to certain tools and techniques? Or is there like trade secrets and formulas that are being used along the way? People, a lot of these businesses think that they're very unique. I would argue that majority of them are not. I've been involved in litigation, and it's a tough battle. And the reason why I say it's a tough battle is because it's highly expensive. So here's the basic Florida statute 542.335. And that basically talks about legitimate business interests that can be protected by an employer. And what it does is it basically says a legitimate business interest is based on special facts of the situation, that it gives the employee an unfair advantage that they would not otherwise have. So if there's a particular way of billing, if there's a particular way of tools and techniques, I really wonder how unique they are to that one particular employer. Restrictions must be reasonable, meaning as to time, area, and line of business, and that the restrictions must be in writing, which means that both sides have to sign off on it. If it's not signed off by the employee, it's not enforceable. So these are the 4 basic things that they're looking for. But then again, Florida is not like California. California is much more physician-centric. Florida is much more employer-centric. So what Florida statute specifically states, it expressly states that a court of law cannot consider the individual economic hardship that they would be going through if they weren't allowed to work. They can't even look at that. So, although that can be presented in court, I've argued it, I've won on it, but I've lost on it too as soon as the other side brings it up and says, hey, the statute specifically prohibits the court from even considering economic hardship. So it's an interesting area, and you got to be very careful as you navigate. Keep in mind there was a case.
Ben, you do have a question in there too. Hi, Jerry. Just came up with a question.
Well, hi, Jerry. Yeah, the solicitation clause is very problematic. That is very true. Patients should have the right to see the physician they choose to see, which is what this Ira Jacobson case is on. You're ahead of me. Jerry, stop getting ahead of me. There may be an element of antitrust violations when this occurs. I think that there's actually antitrust violations occurring all over the place. And there's very little attention going to it. The Department of Justice has considered no poaching agreements illegal. Yeah, that's true. It's considered that, and we'll get to the Department of Justice's position too. But in Florida, it's not like the rest of the country, guys. So, all right. So back to this, and here is an interesting case, and I want you to be aware of this, because a lot of people think that once they become employed and they get a non-compete handed to them, let's say is 6 months into their work, that it would be deemed illegal and improper. Not in the state of Florida. In other states like California or maybe New York, yes, maybe it would be. But in the state of Florida, that's not true. There's a case called Open Magnetic Imaging versus Mirza Nieves. And in there, Mirza Nieves was literally handed a non-compete agreement in her hand after she had already been working at the employers for a good number of years. And she was restricted to a 10-mile radius for 2 years. And she thought she could get around it. Guess what? The courts decided, no. Because Florida is a at-will employment state, that the consideration for continued employment in exchange for that restrictive employment agreement is deemed to be enforceable. It's considered adequate consideration for them to be able to continue employment if they sign off on the agreement. What the courts basically say is, if that the employee doesn't want to work under those conditions, they're free to leave. But if they want to continue to work, they want to stay there, they've got to sign that agreement. Highly problematic, right? In California, I'm pretty sure that's not the case, although I'm not a California attorney, but I'm pretty sure that's not the case. Here we go with the Department of Justice and what the Department of Justice has said. As of recent, there was a case earlier in 2022 that was the Samuel Beck versus Pickard. And this is the case you might be referring to. And in there was a Department of Justice amicus brief, where basically what they said is physicians joining a practice and the practice's competitor should not be prohibited from changing from one company to another company because it's a horizontal restraint, meaning moving from one employer to another employer. The post-employment non-compete may be an attempt to allocate territories. So again, that goes to the antitrust issues that we were just talking, that the question was just raised about by Jerry. And, you know, Jerry's right on spot with that. He's on spot with the way the Department of Justice is thinking. Now, how far is it going to go in Florida courts? I'm not so sure. It hasn't quite, this Pickard case, the Samuel Beck v. Pickard case has not made it to Florida yet, guys. It's still in Nevada. You know, and these are just general words of advice. So I think the physicians need to be careful. Now, we were talking before the seminar actually started that the FTC, the Federal Trade Commission, has also issued some new proposed rules that are being reviewed currently. They're open to a commentary period, and we'll see how far that gets. But they're really, really liberal rules, and I frankly don't see them making it through. I think they're going to go through a lot of scrutiny. So that's where the Department of Justice is and their position. I'm going to speed it up a little bit, but keep in mind, as you go and work for an employer, if they get bought out by another company, do your restricted covenants carry on from the old company to the new company? And you know, that's a function of multiple agreements. It depends on what sorts of clauses they have or don't have. And so I would look for assignment clauses, and I would negotiate to do a revision of those. Because, for example, if there's a small practice that gets, let's say, bought out by a much larger company, like let's say a Mednax or something, all of a sudden, do all of those Mednax practices, are they now deemed to be places that the employee has worked? And are they, you know, is the new place of employment going to then be in direct competition with this large employer? Interesting scenario. I think not, but it can certainly be argued that. And I tell you, you got to handle it carefully. So when you're negotiating a non-compete provisions of your contract, make sure that the geographical limitations are limited. Make sure that it's really for a limited time frame. So like if you've only worked in a place, let's say you've been working somewhere for 10 years, but for the last 2 years, you've been only at this one particular situation or one particular facility, then all the other 8 prior years really should not apply. I mean, because you've literally now limited your practice to one facility. It's important. If I were you, you see the camera sign there on the slide, you may want to take a picture and have this thing handy, because you need to know what you're going to be negotiating when it comes to non-competes. The other thing is you got to make sure that the non-compete is fair. 2 years or less is generally deemed to be fair. What happens to the contract or the restrictive covenant when the assignment clause says we can assign this? Guess what? You're under the obligations of the new employer, who may be much larger. It's problematic. Also, make sure that the contract is specific to your scope of services. So now, let's say you're an emergency doc or an anesthesiologist. Make sure that it only applies to services as they relate to emergency doc. What if you, as an emergency doc, tomorrow decide to go do, I don't know, primary care or geriatric care or something like that? It doesn't apply to those areas. Make sure that it stays specific to that area of practice. Last but not least, consider putting in a buyout provision in your employment agreement, meaning if you do happen to violate, that you would be willing to pay a penalty just to make sure that you stay out of the court system. A court system battle, I can assure you, it will be very expensive, very costly, and time-taking, and heartfelt, because you're going to feel the pain of it. So take a picture of this, keep that on your camera if you need to, and let's we'll leave it at that. Next, and this is my last topic that actually, let me see. Oh, this is my second last topic. So make sure you understand the difference between occurrence form of professional liability insurance versus claims made insurance. Occurrence form is a better form of professional liability insurance. Claims made is not as good. However, there are ways around it. The way to get around it is to either get tail coverage or nose coverage into your new insurance that you're picking up. So here in this diagram, you can see, like, if an incident occurs during the policy period, what happens post-policy period? Well, under the occurrence form practice, you will be covered by that insurance coverage. Under claims made, you will not be covered.
Ben, there's one other question in there off of this topic, before this topic.
Hey, will future employers pay for buyout provision? I have not seen that happen, but I can see it as I've had it happen under business executive scenarios, but not under physician scenarios. I wouldn't doubt it if they would. I think it's actually good to ask, but you got to have, let's say you're employed by employer A, and now you're looking to go to employer B. Employer A has to be open to the buyout provision if it's not in your contract. If it is in your contract, then you will have the ability to obviously go and ask your new employer to say, hey, pay for my buyout. And they very well might. I mean, I would not be surprised if they are, because remember, as things progress over time, we know that there's a shortage of physicians already, and that shortage is getting bigger and bigger. So meaning, like, there's going to be less and less physicians in comparison to what's needed. So we know that that's growing, and I think that's always open room for discussion. Now let's talk about employer obligations.
Wait, go back to you didn't finish the other one yet.
Sure, on this one here?
Yeah, I think you finished it.
Oh, I thought I did. Do you see any particular thing you want me to
No,
touch on?
just kind of clarify when you need to buy the tail or the nose coverage again.
Okay, so all right, so yeah, thanks, Charles, for slowing me down. I know we're 40 minutes plus into this, so I want to just anyway. So what tail coverage basically means is if you get claims made insurance, you can pick up tail coverage and you can go and buy it. In the relative scheme of things, it's not that expensive. It's overall relatively cheap to pick up, but I would pick it up. That's one scenario. The other scenario is pick up nose coverage, meaning if you leave practice A and you go to practice B, ask practice B to ask their insurance company if they will get you nose coverage, so that all of your prior incidences, now even though you're going into this new employment situation, is covered and picked up by the new insurance company. That's called nose in, right? Tail out, nose in. So it's called nose in coverage. And you can ask for that. I think I've done it, I've seen it, it happens, and it's easy enough to do. It's relatively inexpensive. I think nose in coverage is probably cheaper than tail coverage. Don't quote me on it, but I think the nose coverage is probably cheaper. You could even probably tell your new employer, hey, I'll pay for the nose in coverage myself. Just let me know how much of an additional premium it is, and I would find that out. Just make sure you figure out the mechanics of it. All right, now let's move into employer's obligation. As a physician, you are responsible for taking care of all of the clinical issues, right? But now, what is an employer responsible for? Heck, I think they're definitely responsible for accurate record keeping, right? Record keeping is a essential part of taking care of patients. So that responsibility clearly lies in the hand of the corporate employer. There's also things like making sure that you have a clean and suitable environment with ample supplies and equipment. If that's not there, that's problematic. So, these are all of the obligations that go to an employer. The other thing that I've seen happen is a lot of employers are really, really bad at giving messages from patients to physicians, meaning when the patient calls in, the message never makes it over to the physician, and the physician didn't get to reorder a prescription that the employee that the patient needed. Now, guess who they're going to blame? They're going to blame the physician for never returning their phone call. So it's really important. When this sort of stuff starts to happen, I think you've got to take a second look at the employer. And also, some employers, believe it or not, they take a kickback from other places. And although it's under the table, although it's hidden, you've got to be mindful of it. And last but not least, make sure you keep copies of these occurrences and you raise the issue with your employer. Here, I'm going to take this question from that's in the chat box. Oh, thanks, Aaron. So on this, take a look at what's in the red on the bottom, right? Take a picture of this slide too. I suggest that whenever you do work for any employer, ask for a detailed billing report under your NPI number. If they say they cannot give you a report under your NPI number, start looking somewhere else. And the reason why I say that is because, number one, there's no transparency in that organization. Number two, you don't know where your NPI number is getting used. So it's of serious concern. They should be able to run reports for you by location, by patient, by your NPI number, by even the different kinds of codes that are getting coded under your name. And also, if you are actually the primary to a particular patient, you may want to take a look at how many other ancillary services, whether it's drugs or whether it's certain treatments or whether it's certain tests that are being performed by the practice on your patient. So whether you're a general practitioner or whether you're a radiation oncologist, who's getting what from your business, right? From related to your patients. This will give you a full feel for what you're worth and the impact of your service to the patient. The other thing you need to keep in mind is, what do you do post-employment? Post-employment, if you have a non-compete agreement.
One other question, Ben, from Jerry, a quick question you see in there.
Sure. I don't see it, Charles.
What is the likelihood that employers, including hospitals, will hold employed physicians hostage via their employment agreement by making them pay for tail coverage and perhaps giving up their hospital privileges?
It depends. I think it depends. What's the likelihood? I don't know. It's hard to guess, but I'll give you the variables that go into my calculation of trying to figure it out. It depends on how hard that particular institution recruited you and how easy are you replaceable. If you're easily replaceable, I'm not so sure that they're going to go after you a whole lot, because really to ask you to have tail coverage is really their way of harassing you. Or if they think that you actually committed some sort of wrongdoing while you were working for them, they're going to want you to carry that tail coverage. So they may actually, it's just going to depend on the special circumstances that you're in. If something was done improperly and repeatedly, I could see a former employer saying, hey, pick up coverage. And I don't think that would be out of place. But I can also see them picking it up as, because they don't want you leaving, they want to scare you into staying. and then holding it over your head that you didn't do something, or just to be able to haul you into court. So this is what I want you to do, is take a picture of this. You see the writing in red? What can you do to preempt post-employment restrictions? Here are, in my book, the basic 4 things you can do. Number 1, build a social media presence. Get to know your patients on a personal sort of a basis. Semi-personal, but it's like a personal professional, right? Get to know them that way, because then they know where you are. Even though you may be restricted from sending them letters like, hey, come over to my practice because I moved from, I don't know, let's say Oakland Park to Hollywood or something. You know, they still have the ability to find you. Another one is, you may want to consider starting up an advisory website. Like, for example, you may want to have one like drsmith.com, or in this case, like I put in drben.com. I don't know, there's probably one that actually exists, but set up your own advisory website, start putting articles in there. When you see a unique scenario, throw it onto the website, have your patients follow you, give them guides that you want them to look at, whether it's the healthy guide to, a diet, or the healthy guide to exercise, or whatever it is. Just make sure that you start to gain a following. The other thing that you are also not restricted from doing is sending out general advertisements. If you know that your patient base is in a particular geography, generally you're not restricted from doing a general ad. You could do postcards and mailers. There's nothing wrong with that. And I've never seen a employment agreement that restricts a physician from doing that. Also, you can think about advertising in the local papers. Sometimes there's bus benches. Sometimes there are association papers. So like, for example, if you happen to live in Pembroke Pines and you know Silver Lakes is a big association, you know that they have a community association paper. And in that community association paper, you could probably take out an advertisement that basically says, your office location is now at such and such place. So you could do that. You could even do Google and Bing and advertising and so forth. And the unique thing about bus benches is, wherever you last practiced, there could be a bus bench nearby that practice. And if you happen to take out an ad near that near that practice, it would be sitting right there on a bus bench. So you may in fact have patients driving by seeing your ad. Now, is it likely that somebody's going to pick a fight with you for these sorts of general advertisements? I think not, because I think it's actually a losing argument. Could you snare a fight? Yeah, you might snare a fight from it, but I wouldn't be shy of taking one on in this sort of a setting, because this is very general post-employment sort of ways to get around the restrictive covenants. Now I'm going to touch on, last but not least, litigating non-competes. There are basically 7 things you can do. You can take a picture of this as well, and you're just going to have to keep these rules in mind, keep them handy, because I think the Florida courts have the ability to actually blue pencil a non-compete agreement, and those non-compete agreements, when they're blue penciled, they have to be narrowed to something that would be reasonable, but it's an uphill battle. Anyway, with that said, I think I'm past my 50 minutes, and we're up to 53 minutes now. If there's any last questions, I will take them. If you'd like to call me, you're welcome to reach out to me. If you notice down here at the bottom, here's a 15-point checklist that's on my website. If you click on that, once you get this presentation, you're welcome to go to it. Just click and check, make sure that your employment contract addresses these things. And I think you will be much better off for it, because remember, you don't know where exactly your next step is. You got to keep an eye on the horizon, on your 5-year and your 10-year forecast of where your career is headed. So that's why it's really important to look at the stuff. And with that, I will stop.
Well, thank you, Ben. I appreciate it. Are there any questions that anybody would like to unmute themselves? We still have a couple of minutes that you might like to ask. I see none. Well, I want to thank you all for joining us tonight. The next legal webinar in our series is going to be on February 21st. Again, that's the 3rd Tuesday of the month and the topic's going to be board orientation, or as I like to say, what to know and how not to be sued as a board member. Basically, your legal liability, and if you don't ask the right questions, people like to sue boards of directors, and nothing else. Make sure you have insurance. But it's important to, from Ben, we've done this. Now, I think this will be the third time we've done this. And it's very important for yourself or if you're going on some boards for a nonprofit or a for-profit company, it's nice to know, it's nice to be asked to sit on the board of directors, but know what you're in for. Am I right, Ben, on that?
Yeah, know what you're in for. You know, the thing is with when people join boards, everybody's eager to join boards. But guess what? It's not always a cup of tea to actually go and join in on, because what ends up happening is it's kind of like you know, a healthcare institution, right? If one person inside a healthcare institution is excluded from Medicare, the entire enterprise is deemed to be excluded. So it's almost like a disease, right? It's almost like an infected person. When you're in a board and you join hands and hold hands with other board members, you got to be super careful. You don't know what you're about to step into. It creates a certain level of liability. You're responsible for overseeing a lot of functions inside an organization. And we're going to talk about those things, what to look out for if you ever decide to be a board member. And I think a lot of people just overlook it. They just want to become board members, you know, because it's so much fun and it's great. It feels good. But at the end of the day, as a board member, you are taking on a risk. So we're going to talk about that and what to look out for.
Well, again, I appreciate everybody coming on tonight. We've kept to our 1 hour. It's 7:29. So again, I appreciate it. And we will be sending out a PDF copy of all the slides to you. And like I said, the video will be available hopefully by the end of the week, once we get up and running on the website. And if you do have any questions, you can email me. Ben's email address was on that last slide if you've seen it. Ben, if not, tell them what it is real quick.
Yeah, my email address is BAM, as in BAM, my initials, at mirzahealthlaw.com. MIRZA health, HEALTHLAW.com. And that's my email. If you would like to call or text me, you're welcome to text me, because texting me is an easier way to get a hold of me. It's 954-445-5503.
And if you need any of those numbers, email address or whatever, you can just get a hold of me. You obviously know where I am because you found this event. And again, we'll be emailing that stuff out to you within a day or so, and being able to watch the video.
Before you go, what I do, and I kind of just wanted to mention this, and I don't mean to advertise. We do a fixed fee employment contract review for physicians. It's generally $875 to do the review. We give you a fairly comprehensive report. We even do background checks on a couple of people that you may want to do background checks on while you're doing it, so you make sure that you don't join the wrong group. That's one thing. And then the other thing that we also offer is a $125 discount to any graduating resident or fellow if they're entering into so for them the cost is a bit less. It's $750.
That's great. So if you need Ben's services, like I said, if you're not going to use Ben and you have a problem, make sure you do use a real good attorney to make sure you don't get into worse problems than you may currently be in. So with that, we'll hopefully see you next month. You'll get my newsletter on Thursday, and I'll have the link to register for the next meeting on February 21st. And again, have a good evening, and we'll see you next time. Thank you.
Hey guys. Okay, bye-bye.